The case law we're going to examine in this slideshow is Honig v. Doe, 484 U.S. 305, a case that concerns the suspension and expulsion of exceptional students. This presentation has three components. First, I'll share the background information and circumstances surrounding the case. Then I'll explain the case's trip through the lower courts before going into the details of the Supreme Court's ruling on this particular case. The case Honig v. Doe primarily concerns the suspension and expulsion of students with emotional disturbances. The suit was brought forward in 1980 by John Doe and Jack Smith, students of the San Francisco Unified School District, against Bill Honig, the California Superintendent of Public Instruction. Doe and Smith were students identified as having emotional disturbances on their Individualized Education Programs, or IEPs. Each was suspended indefinitely following violent outbursts at their respective schools, while the school's expulsion proceedings could be completed. Doe filed suit against his school district, SFUSD, for violating the stay put provision under the Education of the Handicapped Act, or EHA, which predates IDEA. This provision maintained that students with disabilities must remain in their current educational placements until the completion of any review proceedings. Doe alleged that the expulsion proceedings triggered the stay put provision and that SFUSD violated his rights in suspending him indefinitely. The district judge granted Doe's request for a preliminary injunction ordering school officials to return him to his existing educational placement pending a review of his IEP. The district judge found that the expulsions and suspensions of students for behavior caused by their disability deprived them of their congressionally mandated right to a free, appropriate public education, as outlined in the EHA. The district judge barred the school district from taking any disciplinary action other than a 2 or 5 day suspension. In addition, SFUSD was prohibited from effecting any other change in the educational placement of any such child without their parents' consent, pending completion of any EHA proceedings. Honig appealed to the district judge's ruling and took the case to the Court of Appeals for the Ninth Circuit. The Court of Appeals affirmed the district judge order with slight modifications. Honig argued that the stay put provision needed a dangerousness exception to suspend students with disabilities that pose a threat to themselves and others. The court agreed that an indefinite suspension in aid of expulsion constitutes a prohibited change in placement. The case was heard by the Supreme Court in 1987. There were two main questions surrounding the case. The first, is a claim brought under the Education of the Handicapped Act moot if the claimant is over the age of 21? And two, is there a dangerousness exception to the stay put provision allowing schools to act unilaterally in suspending students that pose a threat to themselves and others? The final decision ruled in favor of Doe, 6-2. The dissenting justices were Justice Scalia and Justice O'Connor. In regards to the first question, the court found that although the claim of now 24-year-old John Doe was moot, Jack Smith was 20 and had not yet finished high school. Smith was eligible under EHA rules to return to public school in California, and his rights were at risk of being violated. Justice Scalia dissented with this ruling, unconvinced that Smith would, in fact, re-enter the state school system. Justice O'Connor joined his dissent. The Supreme Court ruled that there is no dangerousness exception with regard to the stay put provision that allows schools to indefinitely suspend students. Their argument was that the intention of Congress to withhold this residual authority from schools. The court further points out that there are other options for educators, including timeouts, detention, restriction of privileges, or suspensions of up to 10 days. The court's response to Honig's argument in favor of this dangerousness exception cites the original legislative purposes of EHA, and therefore IDEA. The legislation was meant to strip schools of the unilateral authority that they had used in the past to exclude disabled students, especially those with emotional disturbances like Doe and Smith. The stay-put provision protects students and parents. It keeps them in their current educational placement unless schools can prove that they would harm themselves or others. The Supreme Court agreed with the Ninth Circuit Court and had struck the proper balance between the free, appropriate public education children with disabilities are entitled to with the safe learning environment for teachers and other students. This concludes my presentation on Honig v. Doe, and I look forward to hearing your questions.